She was just trying to stop a child marriage. Bhanwari Devi was a government worker in Rajasthan, sent to the village of Bhanwari to enforce India's law against child marriage. She tried, and the men whose family she had reported came back. What happened to her that night was not an accident. It was a warning. Her attackers were arrested, then released. The case was closed. But 5 women, who had never met Bhanwari Devi, refused to accept that. They didn't just protest, they went to the Supreme Court of India. And what came out of that case changed the law for 500 million working women. Bhanwari Devi was a sadhan, a Hindi word that roughly translates to companion or helper. She worked for the Rajasthan government's Women's Development Program, going village to village to educate women about their rights, about health, about education, and about laws that existed to protect them. One of those laws was the Prohibition of Child Marriage Act. In the village of Bhanwari, Bhanwari heard that a 1-year-old girl was being prepared for marriage. She reported it. She tried to stop it. The marriage happened anyway. The family whose honor she had challenged did not forget her. In September 1992, 5 men from that family went to her home. They attacked her husband, and then, in front of him, they gang-raped Bhanwari Devi. The men were arrested, but the investigation was handled so poorly, and with such clear bias, that they were eventually acquitted. The session court judge reportedly said that a woman of Bhanwari's caste could not have been raped by upper caste men, that it simply didn't happen. Bhanwari's case was effectively over, but then something unexpected happened. A group of 5 women's rights organizations, collectively called Vishaka, filed a public interest litigation in the Supreme Court of India, not on behalf of Bhanwari's criminal case. That was gone. They asked the court something larger. In the absence of any law protecting women from sexual harassment at work, what rights do they actually have? And the Supreme Court decided to answer that question. Before we go further, you need to understand one legal concept that makes this case possible, and it is one that most people outside India have never heard of. It is called a public interest litigation, a PIL. Here is the simplest way to understand it. Normally, to take someone to court, you have to be the person who was harmed. If your neighbor breaks your fence, you can sue them. But if your neighbor breaks someone else's fence, in most legal systems, that is not your problem. You have no standing to bring a case. India changed this. In the 1980s, the Indian Supreme Court developed a doctrine that said, if a matter affects the public interest, if it affects the rights of citizens who may not have the resources, the access, or the knowledge to approach the court themselves, then anyone can file on their behalf. That is a PIL, a lawsuit filed not for personal gain, but for the public good. Think of it this way. Imagine a road in your city has a pothole that has caused 5 accidents. The victims can't afford lawyers. Nobody is suing. The government is ignoring it. In most countries, that pothole stays. In India, a concerned citizen, a journalist, or an organization can walk into court and say, this is harming people. Fix it. That is the power of the PIL. And in 1992, Vishaka, this coalition of women's groups, used that power to ask the Supreme Court one devastating question. Why does India, a country with a constitution that guarantees equality, have no law protecting women from sexual harassment at their own workplace? At the time this PIL was filed, that was the truth. There was no law, not one statute, not a single protection in the Indian Penal Code specifically addressing workplace sexual harassment. Vishaka argued that this legal vacuum itself was a violation of Articles 14, 19, and 21 of the Indian Constitution. The rights to equality, to practice any profession freely, and to life and personal liberty. The Supreme Court agreed to hear them, and what it did next, no court had ever done before. The Supreme Court of India heard the Vishaka case, and it faced a problem no Indian court had faced before. Parliament had not passed a law on workplace harassment, so the court could not interpret a law that did not exist. It could dismiss the case, could tell Vishaka to go to Parliament. It did neither. In a landmark judgment delivered on the 13th of August 1997, the Supreme Court of India, led by Chief Justice J.S. Verma, did something extraordinary. It wrote the law itself. The judgment invoked Articles 51 and 253 of the Constitution, which allow Indian courts to refer to international conventions, including CEDAW, the United Nations Convention on the Elimination of All Forms of Discrimination Against Women, to fill the legislative gap. The court issued what became known as the Vishaka Guidelines, a set of binding legal obligations on every employer in India, public sector, private sector, organized and unorganized both. Every employer was now required to define what sexual harassment means, establish a complaints committee at every workplace, provide a safe mechanism for women to report incidents, and take action within specified timeframes. But before I tell you how this became law that actually binds you, there is something most people covering this case miss entirely. Bhanwari Devi, the woman whose attack started all of this, never received justice in her own criminal case. Her attackers were never convicted. She lives in the same village in Rajasthan today. Her name appears in every law textbook in India, and her rapists walked free. That is the contradiction at the heart of this judgment. The law it created is considered one of the most important in India's history, and the woman who made it possible has been waiting for justice for over 30 years. The Vishaka Guidelines remained the only legal standard on workplace harassment in India for 16 years, until Parliament finally passed the Sexual Harassment of Women at Workplace Act in 2013. That act, now known as the POSH Act, codified the guidelines into statute and created mandatory internal complaints committees in every organization with 10 or more employees. So what actually changed because of this case? Before Vishaka, a woman harassed at her workplace in India had no specific legal mechanism. She could complain. Her employer could ignore her. Nothing happened. After Vishaka, every employer was legally obligated to act. The guidelines created a right that had not existed before, and the Supreme Court achieved this not by waiting for Parliament, but by reading international law into the Constitution and enforcing it directly. Critics argued this was judicial overreach, that courts are not elected, that writing law is Parliament's job, and when a court does it, even for a good reason, it sets a dangerous precedent. Supporters argued the opposite, that fundamental rights cannot wait for Parliament's convenience, that when the legislature fails, the judiciary must act, that the alternative, doing nothing, was itself a choice to let women be harmed. The POSH Act of 2013 effectively answered the debate. Parliament eventually did its job, but only because the Supreme Court forced the issue 16 years earlier. Today, the Vishaka case is taught in every law school in India as the defining example of judicial activism, and Bhanwari Devi's name is in every one of those textbooks, even as she continues to wait for justice in her own case. Now, here is the part that changes how you see this case, because every country had to figure out this problem, and every country did it differently. In the United States, workplace sexual harassment was addressed through Title VII of the Civil Rights Act, a law passed in 1964. The Supreme Court clarified its application in two landmark cases, Meritor Savings Bank in 1986 and Farrakher v. Boca Raton in 1988. The US had a statutory framework. India had nothing equivalent until 1997. In the United Kingdom, protection comes from the Equality Act 2010, which explicitly prohibits harassment related to sex in any workplace. The burden on employers is significant. They must show they took reasonable steps to prevent harassment, or they are vicariously liable. In Australia, the Sex Discrimination Act 1984 covers workplace harassment, and recent amendments have introduced a positive duty on employers to proactively prevent harassment, not just respond to it after the fact. And in India, the country that had nothing in 1992, a coalition of 5 women went to court with no money and no statute on their side, and they got the Supreme Court to write a law that Parliament had refused to. Same problem for countries. for completely different paths to the same destination. This was the Vishaka case. And if you think this is an Indian story, look again. It is a human one. I am Docket Decoded. Every verdict has a story. And this one, the case behind the POSH Act, was 16 years in the making. Subscribe, and I will see you for the next one.